Hi, everyone. Good morning or good afternoon. Thank you so much for being here with us today. We're thrilled to see so many new friends and so many repeat visitors to our quarterly update here. My name is Sarah Wake, and I'm a partner in the Labor and Employment Group in the Chicago office at McGuireWoods. Prior to coming to McGuireWoods, I spent 9 years in higher education, including as a Title IX coordinator, and most recently the last 5 years at Northwestern University in their legal department, working on issues related to student affairs, athletics, and diversity, equity, and inclusion. I also served on the NCAA's Division I Committee on Infractions, where I was part of the group that adjudicated Division I rules violations for member institutions. My co-host today is the wonderful Farnaz Thompson. Farnaz is the new head of our education industry team, so congratulations to Farnaz on that, and a partner in our DC office, also in the Labor and Employment Group. Prior to joining McGuireWoods, she served as the Deputy General Counsel for Post-Secondary Education at the United States Department of Education, where she worked closely with DOJ on discrimination and administrative procedure act cases. She also served as in-house counsel at the University of Virginia, where she worked on employment and education-related issues and represented the university and its academic medical center in litigation. So Farnaz and I started this program about a year ago. Many of you have been with us since our first quarterly update, and we know what it's like to be in your shoes. So we know how quickly the day comes at you, that you're usually in meetings from the minute your day begins until the day ends, and that it can sometimes be difficult to track all the developing issues in higher education. So we've styled this webinar a little bit differently than most, which is that we review a high number of topics in a short amount of time, and we try to end each section with some practical advice for you to take back to your legal offices or your institutions. We recently started inviting some guest speakers from our terrific education team to join us, and today we are so happy to have Janet and Tony with us. So Janet first is a partner in our Richmond office. She practices in the areas of intellectual property and data privacy and security. She provides worldwide brand protection, enforcement, licensing, and transactional IP services, data security, as well as compliance issues after a data breach. She told me that she holds the SIP US certification in privacy. I do not know what that means other than it's very important in the field, and she had to tell me how to say it. But we're very grateful for her time and her expertise here today. So thank you, Janet. And then last but not least, Tony Tatum. So Tony's a partner in our Atlanta office, and he's the co-lead of our really wonderful insurance recovery practice. He represents prominent public and private companies on all aspects of insurance coverage and related complex commercial disputes. And I've really been lucky to see our insurance recovery practice do some incredible and interesting work with colleges and universities right now, including on some pretty high profile cases. So thank you so much, Tony and Janet, for joining us today. We're very glad that you're here. And we're gonna go through these topics as quickly as possible. We try to leave time for questions at the end, but I don't think we're going to have time for that today. So if you have a question, please type it in the question box. We will receive the questions afterwards, and we'll make sure that somebody follows up with you on a response. So with that, let's dive into the first topic, which is admissions and affirmative action, everybody's favorite topic. So we previously covered the 2 admissions and affirmative action cases pending before the United States Supreme Court. And we've been getting a lot of questions from our clients, both higher education institutions and other clients, asking us, does the holding or the finding or the result in these affirmative action cases before the court impact the employment arena? And the short answer to that question is no. The longer answer to that question is kind of, sort of. And we all know, of course, that affirmative action, as it's before the court right now, pertains to circumstances when colleges and universities can consider race in admissions. Affirmative action in the employment context, often incorrectly interchanged with that in the admissions context, means, of course, that federal contractors have to look at their workforce and look at their applicant pool and really carefully review data related to certain job groups to see how the data for their recruiting and retention practices line up with national availability in certain job groups. And then, of course, recipients, federal contractors, have to take proactive steps, affirmatively take action to try to close the gaps where the data show that you're underutilized in certain job groups. So no, the Supreme Court cases will not have an immediate impact on that. But what we're seeing is arguments similar to those made in the affirmative action cases before the court are now being made in the employment and particularly the higher education context. And one really interesting case that I'm watching closely that I wanted to flag for you is this case Lowry versus Texas A&M. So this is a class action that was filed in September of 2022. The complaint was amended in December. And Mr. Lowry is a faculty member at UT Austin who is suing Texas A&M and their president and under others acting in their individual capacity, alleging that the institution violated Title IX and Title VI based on their faculty hiring and compensation initiatives. And the reason this case is so interesting is that Mr. Lowry has never actually applied for a job at Texas A&M. He's saying that he has standing to bring the suit because he wants to apply for a job at Texas A&M, but because of these discriminatory hiring practices, he's not going to get the job, so therefore he's not going to apply. Mr. Lowry, in his complaint, alleges something very similar to what the plaintiffs alleged in the Supreme Court cases, which is he's alleging that Texas A&M's hiring practices give a preference to women and to non-Asian faculty members to the detriment of men and Asian faculty members. And I would encourage you to read this complaint closely. And if you want a copy of it, please email me and I can send it to you right away. But he's looking at some comments that were made by the president, who was formerly a dean of one of their colleges, where the president says things like, we really need to fill this position with a Black candidate or an underrepresented candidate. He's looking at things like memos from the Office of Diversity, Equity, and Inclusion that say we need to increase hiring in these groups. He's looking at practices pertaining to faculty hiring lines where a search happens and a non-underrepresented candidate is selected, and then the department says, there was a really qualified underrepresented candidate in the pool, and we are going to create a line particularly for that candidate. He alleges, perhaps rightfully so, that those practices run afoul of Title IX and Title VI, and I would say perhaps also Title VII. So if I were you, I would be talking to my president, my provost, my dean of faculty hiring, if you have that position or its equivalent, and my deans and perhaps the folks who do training of search committees to really reiterate to them how we should be talking about diverse hiring and what we should and shouldn't be saying when it comes to filling in particular faculty, but also staff positions. If you're interested in learning more about the intersection between these student affirmative action cases and affirmative action in the employment context, I did a webinar with my incredible colleague who's like a savant on employee affirmative action in November. I've put a link to it in these slides, and we focus much more in depth on this issue of the intersection between these two issues. So second, let's talk about collegiate athletics. So clearly today I got all the fun topics, and in particular about an issue pending before the National Labor Relations Board right now. So last year, a group purporting to represent student athletes filed an unfair labor practice charge against a public school, a private school, their then current, but possibly soon to be former Power 5 athletic conference, and the NCAA. The public school has since left the unfair labor practice charge, which is wise since we know the National Labor Relations Act generally doesn't apply to public entities. The National Labor Relations Board recently decided that this ULP has merit, and the ULP will now issue a complaint. And in doing so, here's what the National Labor Relations Board representative said. They said the private university, the NCAA, and the conference collectively maintained unlawful rules and unlawfully misclassified scholarship basketball and football players as mere student athletes rather than employees entitled to the protections under our law, the National Labor Relations Act. So essentially making good on the general counsels of the National Labor Relations Board's promise from September of 2021 that they will take the prosecutorial position that student athletes are employees for purposes of the NLRA and therefore have the right to organize and engage in other protected activities. This case will wind its way through the system. There will be an ALJ hearing, perhaps the full board will consider it. The Ninth Circuit Court of Appeals would be the next step, and then possibly ultimately the US Supreme Court. I think we know how at least Justice Kavanaugh would come down on this issue, since much of his concurring opinion in the Alston case was about how he thinks student athletes should have a right to organize. This issue with the unfair labor practice charge is happening in a dynamic world of collegiate athletics right now. And I want to flag for folks that another court, the Third Circuit Court of Appeals, is currently considering whether student athletes in all sports, not just football and basketball, so not just the so-called revenue generators, should be considered employees for purposes of the Fair Labor Standards Act. The Third Circuit was supposed to have oral argument on this in January. It was now rescheduled, I believe, to next week. And last week, the Third Circuit issued a letter to the parties saying, hey, parties, at oral argument, you need to be prepared to discuss the implications with Title VII and Title IX if we find that student athletes are employees for the Fair Labor Standards Act purposes. So that's certainly one to watch. I will be watching the oral argument and doing a summary. If you'd like that summary, you can contact me afterwards. And this is, of course, also happening as student organizing is picking up in other arenas, including graduate student unionization, where we're seeing colleges really either try to proactively provide graduate students with increased stipends and benefits, currently in the throes of negotiating with their graduate students, or figuring out other ways to navigate an organizing campaign. So certainly much more to come on this front. One thing I wanted to flag for you all quickly that's not in the slides that I think people really need to pay attention to in the world of collegiate sports, not just Division I. But as of January 1st of this year, the NCAA amended one of their bylaws regarding name, image, and likeness. And what the NCAA said is that in cases involving name, image, and likeness, offers, agreements, or activities in which communications and conduct are subject to NCAA regulation, so this means pay to play and recruiting, in my opinion, the infractions process shall presume a violation occurred if circumstantial information suggests that one or more parties engaged in impermissible conduct. So this means that if the enforcement staff, which is the group responsible for looking into potential rule violations, has enough information to suggest that the institution impermissibly engaged, I think primarily with name, image, and likeness collectives, there will be a presumption of a rules violation. This is a huge deal. And I think that you need to be working with your athletics staff and with university leadership to make really clear policies and procedures around NIL, including staff engagement with collectives and the institution's stance on that topic. So I would much rather be in the position of showing the enforcement staff, here's the policy we wrote, here's the training, here's how we're navigating collectives, than be reactive when the enforcement staff comes and says there's a presumption of a responsibility. So that's a quick overview. If you need more information on either of those topics, you can reach out to any of us anytime. But with that, I'm going to turn it over to my wonderful colleague and friend, Farnaz.
Thank you, Sarah. And we should note that Sarah was a member of the NCAA Infractions Committee, so she's a true expert on this. And she also was quoted in Law 360 along with Dean Erwin Chemerinsky in commentary regarding the affirmative action cases. So stay tuned for great updates from Sarah Wake. Religious liberty cases. This is something that's near and dear to my heart. As an immigrant from Iran, I have a unique appreciation for not living in a theocracy, but at the same time leaving room for people to practice their religion. Kennedy versus Bremerton School District is a case that will impact all schools, at least public schools that are subject to the First Amendment. It concerns a high school football coach who wanted to kneel at midfield after games and say a quiet prayer. He would do this after the game had concluded and after the players and the coaches shook hands. And he was basically told he could not do this. And he did this 3 times and then he was fired. And so this is really a case about the free exercise clause as well as the free speech clause. And the Supreme Court, in a majority opinion, which was 5-3, ruled that Coach Kennedy could kneel at the 50-yard line after a game has concluded because it was really a time where he was acting in his private capacity, not in his public capacity as a football coach, and it wouldn't violate the free exercise clause or the free speech clause. What's really important is that with respect to the free exercise clause analysis, the court looked at whether the school district's policy was neutral or generally applicable, and the school essentially acknowledged that it was not generally applicable, that it would allow other employees of the athletics department to engage in activity at that time that was private activity, but it did find fault for Coach Kennedy and criticized him for not supervising athletes during that same time where other employees were permitted to engage in private conduct. And with respect to the free speech clause, it's really interesting that court used the Pickering-Garcetti framework and first determined, is this private speech or government speech? And although the school district argued it was government speech when Coach Kennedy was kneeling down at that 50-yard line, the Supreme Court held that it was really private speech and that timing and circumstances matter. So the prayer was offered really at a time when other public school employees at the game were engaged in private speech, and so was Coach Kennedy. What's important about these cases is that the school district was relying on the Establishment Clause, and the Establishment Clause concerns were sufficient to justify a compelling interest in both the opinion of the school district as well as the two lower courts. And the Supreme Court didn't directly overturn the Lemon Test. The court didn't say we are overturning the Lemon Test, which is the primary test used in Establishment Clause cases, but the court wrote that long ago it had abandoned the Lemon Test and its endorsement offshoot. And the Lemon Test is the test that almost all schools have been using to deal with the Establishment Clause, and it really relied on an examination of the purpose, the effects, potential entanglement with respect to the state and religion, and whether a reasonable observer could view the activity as an endorsement of religion. In place of the Lemon Test, the court stated that it would look at historical practices and understandings, really an originalist kind of theory of the Establishment Clause, but didn't offer any other kind of concrete test to look at. So with respect to the Lemon Test, it's not reliable anymore, but lower courts are continuing to use it, and Justice Sotomayor, in her dissent in Kennedy, wrote that the court has overturned it. So that's on the free exercise Establishment Clause front. The Lemon Test can no longer be relied on. Continuing on the theme of religious liberty, the Supreme Court also recently granted a petition for certiorari in Graf versus DeJoy, and the Supreme Court is essentially agreeing to reconsider whether, with respect to Title VII of the Civil Rights Act, which is an appointment law, whether the religious accommodations test is if the employer has to bear more than a de minimis burden. So with respect to Title VII, it states that the employer, as long as the employer doesn't have to have an undue hardship, the employer must accommodate someone's religion or religious practices, but the court has previously interpreted undue hardship to mean more than a de minimis cost. So in Transworld Airlines versus Hardison, the Supreme Court ruled that a de minimis cost is really all that a employer must show in order not to accommodate someone's religion. And TWA versus Hardison concerned Sabbath laws and whether an employee of TWA could take Saturdays off. And with respect to Graf versus DeJoy, it really concerns the same issue, but observing Sunday as a religious holiday or a religious day. And the Supreme Court has indicated, or at least 3 justices on the Supreme Court have indicated, that they would not interpret undue hardship, which is the exact language in the statute, to mean a de minimis cost. They would require more of a substantial cost to the employer in order for the employer to deny a religious accommodation. And this is important, especially in light of the religious liberty cases concerning vaccine mandates, Sabbath laws, religious garb, and other conduct. So what we're seeing is, as we're looking at court's jurisprudence on the free exercise clause, is that they have abandoned the Lemon Test. We would not rely on it to determine if there's an Establishment Clause violation, and that context matters. So the context of the religious activity is really what we should be looking at. And there's a trend with the Supreme Court toward really being sensitive to government actions that disfavor religion, religious speech, or religious practices. So if you're a public institution subject to the First Amendment, what I would do in these types of cases is I would look at what's the activity and how would the school treat that activity if it was not religious. And if the school would ban the activity if it was not religious, then it's probably a good, you would look at those factors and how the school would treat non-religious activity and then treat the religious activity or the religious request for an accommodation the same way. And if you're providing accommodations for reasons other than religion, how do you treat those accommodations? Those are the types of concerns that I would look at. With respect to regulatory updates, the U.S. Department of Education has been very busy, and we're just going to briefly touch on some of the high-level changes with respect to the borrower defense to repayment regulations. These regulations have been targeted at for-profit institutions, but really they affect all institutions, for-profits, nonprofits, and the regulations were issued November 1st, and they're going to become effective July 1st. And one thing to note is that all pre-dispute arbitration agreements and class action waivers that concern federal direct loans or provision of educational services for those direct loans, those are no longer applicable. Schools cannot use those. And the department in its regulations that take effect on July 1st has provided language to insert in pre-existing agreements to make sure that students know that they no longer apply going forward. Now, the borrower defense to repayment regulations, there's 4 iterations of them, and the most recent one is probably the most expansive one. The authority for these comes from Title IV and a statute that just concerns direct loans. But in the past, if a student consolidated consolidated loans that were not direct loans, such as a Perkins loan or a FEL loan, into a direct consolidation loan, then that direct consolidation loan would be eligible for a borrower defense to repayment claim, which means that the student is saying the school took some action or made some omission, a misrepresentation, and I am going to apply for loan forgiveness just for my particular loan. And the new regulations that are set to take into effect July 1st basically broaden the loans that may qualify for federal student loan forgiveness by allowing a direct loan or any type of loan, like a Perkins loan or a FEL loan, that could be consolidated into a federal direct consolidation loan to qualify. That's a broader swath of loans because students have not traditionally been savvy enough to consolidate their loans, and this would make the federal borrower defense to repayment regulations available to a larger group of students. The federal standard that the department issued is one for students who currently have a balance due. So if students have paid off their loans, this would not be a scheme that they could take advantage of as of July 1st. And the department decides these claims based on a preponderance of the evidence standard. The department has new types of borrower defense categories. So the department is going to be looking for substantial misrepresentation, and the substantial misrepresentation definition is new. The department's also going to be looking at whether a school made an omission with respect to education programs or activities, employability of graduates, and there's a long list. Breach of contract claims, and this doesn't have to necessarily be a true breach of contract, but more like an agreement. The school made a misrepresentation about the type of services it would provide. Aggressive and deceptive recruitment, that's a new category. And that matches a little bit of what the CFPB is also doing in this space. If the student has a judgment against an institution, that's another category that would allow the student to move forward with a borrower defense to repayment claim. And finally, if there's a final agency action by this U.S. Department of Education against a school, that is a ground for a borrower defense to repayment claim. So be careful in making agreements with the U.S. Department of Education, because those actions, the enforcement actions and any resolutions that arise out of it may actually now be grounds for a borrower defense to repayment claim. What we should really pay attention to is that, yes, students may file their individual claims, but for the first time, the borrower defense scheme can be brought not just by students or the Federal Department of Education, but by nonprofit legal aid clinics for groups of students. So the student doesn't even have to opt into this group. If a legal aid clinic comes forward and says, I'm filing on behalf of a group of students, almost like a class action, a student doesn't even have to opt into it if the claim and the exact grounds would include that student. And what's really new is that states, including state attorneys general, state agencies, and state regulatory agencies also may file group claims. And we know that, unfortunately, education has been politicized. So we've known that the Democrat states have traditionally targeted for-profit institutions with respect to loans and representations. But now I think that what we're going to see is we're going to see some of those Republican states file group claims with respect to some institutions. So this is something to be looking for and something to be informing your boards about, that this new regulation would allow for state attorneys general to file group claims for students and federal student loan forgiveness. And then after the department forgives the amount of the loans, the department could actually recoup it from the institution. Other regulations that are on the horizon, the department has indicated in its unified agenda that the Title IX regulations likely will be published this May. And the department also is going to undergo a new round of negotiated rulemaking on various topics that are listed in our slide, including accreditation, state authorization, and distance education. If you have an interest in being influential about any of these regulations, you can try to appoint a representative for your sector during negotiated rulemaking. And of course, after a notice of proposed rulemaking is issued, you should absolutely be prepared to submit comments. And with that, I will turn it over to my partner and colleague, Janet Peyton in Richmond, to talk about data privacy.
Thanks so much, Farnaz. Hi, I'm Janet Peyton, and this is a short list of some hot topics in the area of data privacy and security. So this is a little agenda of what we're going to cover. There's a lot going on at the state level. GDPR is still here. I know you don't want to hear about that. And, you know, breach incidents and particularly ransomware incidents are plaguing many, many schools. So first, the state laws. Probably all of you have heard about the California law that became effective a couple of years ago, but they have just amended it, and the amendment was effective January 1st. This is the first GDPR-like privacy law at the state level in the United States. And it gives, the purpose of it, just like GDPR, is to give consumers meaningful control over their personal information, including being able to limit sharing and selling of that data to third parties. So this is important because, particularly with respect to California, California's law has a private right of action, and the plaintiffs' bar, as they are wont to do in California, is in a bit of a frenzy. So here's the punchline. It does not apply to nonprofits right now. Now, obviously, I know some of you are for-profit, or some of you have for-profit arms, and all of those businesses are subject to this law today if you meet the threshold that you'll see in the fourth bullet. But I predict the day is coming when this law is going to apply to nonprofits, and we'll talk about that more with Virginia. So Virginia was the second state after California to pass a consumer privacy law. And frankly, it's not often that Virginia follows California that quickly. But in 2017, when both houses of the Virginia legislature and the governor's seat were held by Democrats, the Virginia Consumer Protection Act, Data Protection Act, was passed, and it became effective this January 1. It's the same as California in terms of not applying to nonprofit schools, not applying to nonprofits generally, but I'll just give you a little inside baseball, because I saw the original drafts of the legislation and I was involved with the stakeholder committee that put it together, and it did not have an exception for nonprofits. That change was the result of some effective lobbying. But I think that is going to change, and it's just a question of when with respect to all of these states. Because if we put aside our higher ed hats and think about the public policy here, there's really no public policy reason to exclude nonprofits from having to handle personal, confidential information in a careful way and to allow people to make choices about it and so on. If you're trying to give meaningful control to people, having this huge group of companies and entities that are not subject to it is a pretty big hole. So considering that it is something of a heavy lift to get compliant, it's a great idea to just start thinking about these principles of consumer control, having robust disclosures, limiting sharing with third parties, so that you're, first of all, just as a best practice, but also so that you're not completely blindsided when these laws are updated. I want to talk a minute about the Illinois Biometric Information Privacy Act, BIPA. This is actually an old law. It's been around a long time. But we are starting to see, and we have seen for a while now, some class action activity around this. And this is not limited to for-profits. So it restricts the collection and use of biometric identifiers. So for example, if you have dorms that have fingerprint locks, or if you use retina scanning, or any kind of, biometric identifier for the purpose of identifying an individual, then you have to have affirmative consent from those people ahead of time to collect that information and to share it, and it cannot be sold. So it's just important to know that this is out there. And there was actually, on February 2nd, the Illinois Supreme Court held that all claims under BIPA are subject to a 5-year statute of limitations, which was up in the air before. So it's good to know that that exists. There were a couple of cases recently that really are important, I think, on this class action stuff in terms of how schools are dealing with virtual testing. So the Powell versus DePaul case, a student brought a putative class action alleging that the use of Respondus facial recognition software, which a lot of people use, violated BIPA because the university was capturing and storing biometric information without the affirmative consent that we just talked about. And the court agreed that's not subject to BIPA under the Gramm-Leach-Bliley exception. So Gramm-Leach-Bliley is a privacy statute that is specific to financial institutions, and that's why you get a privacy notice from your bank and your credit card every year. And the BIPA statute says if you are subject to Gramm-Leach-Bliley, if you are a financial institution, as that term is defined, then you are not subject to BIPA. And DePaul argued that and was successful. But in Patterson, which was just decided, less than a month earlier, the court took a slightly different position, although they didn't say that you're not subject to, they didn't say you're subject to BIPA and not give the GLBA exception, but they denied the university's motion to dismiss because the facts, they said, did not establish that the university was significantly engaged in lending. So it's just worth knowing that there is a little wiggle room here, and it's not necessarily going to be the case that you can get out of compliance by saying we're a financial institution under GLBA. Better to just get the consent. So after California and Virginia, we have 3 more states that are going into effect later this year. Colorado and Connecticut both have consumer privacy laws that go into effect July 1st, and Utah goes into effect December 31st. And the Colorado statute does not have a nonprofit exception. So very important. Now, it does have an exception for data that's subject to FERPA or HIPAA, or their own state higher ed institutions. So that carves out a lot of people and a lot of data. But if you are a Colorado school, private school, or if you have, and if you're a school that has, which almost everyone does, some HIPAA data, some FERPA data, but then you also have, marketing data and other kinds of data that are not subject to those federal statutes, you could still have some issues here. So then just look to the threshold. All three of these states have the same threshold for when the law applies. It's kind of like a small business and therefore small school exception. You have to have 100,000 Coloradans data in your database. You have to be processing 100,000 annually, and processing includes storing. So even if you didn't collect it annually, if you have that many, then you're going to be subject to this statute. And it also picks up what we would basically call data brokers. That's what you see in Romanet 2 there. That typically doesn't apply to schools. So just keep in mind, this is an example of the fact that we are moving, I believe, toward these state laws applying to everybody. I think that day is coming. The Utah statute is virtually a copy of the Virginia statute. It is literally almost word for word. There are a couple of differences, but those differences are where it's looser. It took a few things out, but otherwise it's basically the Virginia statute. Colorado and Connecticut have a lot in common with Virginia, but they also picked up a couple of things from California, like the definition of sale of data, which is very, very broad. So, just to understand that these laws are out there, and it is possible if you're a for-profit or you have for-profit entities within your umbrella organization, that you need to look at these and think about compliance. So I said at the beginning, I know everybody is so sick and tired of GDPR, and I'm just going to mention it because it is surprising to me, considering how long GDPR has been in effect, how many schools are not compliant, are not even close to compliant, are not even trying to become compliant. And so I just put it out there to say, if you think your school is compliant, you might just check, just ask, who's responsible for this? Who did we have look at it? Because there's a lot of misunderstanding about it. On the one hand, there's sometimes misunderstanding that it applies when it doesn't, because the fact that you have data in a database about people in the EU does not necessarily mean that GDPR applies to you. But if you are targeting people in the EU or the UK, if you're soliciting applicants, if you have an establishment of any kind there, a little office, an employee, those things are going to trip that wire automatically. Another thing that we see a lot is that the privacy policy will just say, we are compliant with GDPR. Like, we take all steps to comply with GDPR. Well, so that's not true, because GDPR has very specific disclosure requirements. And I have seen a number of schools, again, really surprising to me, with that kind of a statement and very obviously not in compliance. And the last thing I'll say about this is there are lots of folks that misunderstand GDPR, lots of US lawyers that misunderstand GDPR. I really recommend that you have EU or UK counsel help you with this if you need help. It's important that you are getting advice from someone who is licensed in that jurisdiction. And of course, shameless plug, we have terrific privacy lawyers in our London office and would love to help with this. Okay, just a minute on data breach. So this is a little checklist. If you don't have these things, you really ought to be thinking about implementing all of them. Everybody should have an incident response plan and an incident response team. Now, the Blackbaud breach in the summer of 2020 sensitized a lot of institutions to the risks and costs of data breach. And so some folks have gotten some of these things in place in the last couple of years, but it is so important to know who to call and to know who's in charge and to have a roadmap before this happens. I can't stress that enough. The other thing that's incredibly important is prevention. So one of the key things for prevention is having a document retention and destruction policy. You ought to have policies about where your data is stored, who has access to it, when it gets deleted. horrible data breaches, really large data breaches where the institution or the company should have had about 1/10 of the data that it still had. Former employees from 50 years ago with social security numbers. If you have a breach and all of that is accessed, it's going to explode the cost of the remediation. And it's embarrassing as well. It's also important from a prevention standpoint to do training. If you train every year, you will prevent some incidents. Train your employees, train your faculty, and train your students, frankly. Have an annual, click-through training and have some kind of, remedy if the person really doesn't get it. If they fail, there ought to be a little bit of remediation required. You also want to be sure you have contract provisions that deal with data, treat it as confidential, obligate your vendors to indemnify you for their breaches. Many schools now have a standard data protection addendum, and you should. And these state laws that we were talking about, like California and Virginia, have requirements that you have data protection contract language in every contract with anyone that you share data with, any downstream vendor. Because having all these protections at your level doesn't help if you're sharing it with third parties and they can do whatever they want with it. You're telling people, we don't sell your information. But if your contract with your vendor doesn't say you can't sell this information and you can't use it for anything except what we told you to do, then there's really a huge hole there. And then if you have a data breach, it's important to know that those requirements are dictated by the state of residence of the affected individuals. So that's a huge misunderstanding. Many people think it's going to be governed by the state that they're in. It will be with respect to residents of your state, but not with respect to all the other people. It can be up to 50 states. And lastly, but not least, ransomware. So I'm just going to touch on this very quickly, but there have been a lot of changes recently with respect to the government's approach to ransom and ransomware. It's really important to ask yourself, first of all, are we even in a position to pay the ransom? Can we secure cryptocurrency, which is what you would have to do? Do we have operational stability without it? What about our reputational risk? These are critical questions to ask, but even more critical, and this has really become, this is a very hot topic now, is that there are OFAC sanctions with respect to certain cyber actors and particular types of crypto wallets. And it's really important that you don't just consider paying without having an expert advising you and without screening the other party to be sure that they're not on a list, because you could find yourself violating OFAC sanctioned countries and people, and then you have a much bigger problem. So truly, it's not something to do unless you really, really have to. If you do not have adequate backups and or if human life is at risk, those are the two situations where at least you consider it. If you have backups and it's just a pain and the price is low, don't do it. You're dealing with criminals and they will come back. They often do restore the system initially. About 80% of the time they restore the system, but then they will come back and attack you again. It's very common, well over 50%. So something like 68% of those who pay are hit again within a month. So it's, tempting when the price is low and they make it tempting, but it's really not a good idea. And think about cyber coverage. If you have cyber coverage, you need to talk to your insurer about whether they'll cover it if you're in an unusual situation where you really do think you're going to need to pay it. And, there are all kinds of cons in terms of what happens to the data. The fact that they restore it, and remember, you're never going to get full restoration. You'll get some of it, but they never stand your system back up so that it's perfectly, useful the way it was. But even so, there's really no way to guarantee that that data has not already been sold anyway. There's just not a whole lot of honor among thieves, honestly, even though they'll try to tell you there is. The threat actors will give you a big speech about how we're just a business and we're on the up and up, and if you pay us, blah, blah, blah. Don't believe it. So that is it for data privacy, and I'm going to turn it over on that note to Tony Tatum to talk about insurance, which is very timely because you need to have cyber insurance for data breach.
Thanks, Janet. Appreciate it, and glad to see a lot of familiar folks signed up today. We are, as alluded to at the beginning, going to cover a lot of territory, and that's going to be the case for insurance, both on the claim side and on the underwriting. And of course, if you have follow-up questions, we look forward to getting those. But just to start off, where Janet was discussing a ransomware or data breach, is cyber insurance really a solution? The answer is yes, in most cases. And cyber insurance is one of those types of coverage that includes, in almost all cases, both first-party and third-party liability coverages. And we've listed a few here. Of course, third-party liability coverage for data privacy class actions, any similarly PCI DSS assessments that may have to be paid to banks or credit card companies for failure to comply with PCI DSS standards. Another third-party coverage that's in most cyber policies would be for regulatory claims, where there may be an inquiry after a data breach by state AGs or having to work with state AGs regarding notifications. And as Janet alluded to, it's the requirements are different under each state's laws. In most cases, a first-party coverage, and an important one, is the forensic investigation, legal costs, those things that are front and center and have to be taken care of in the aftermath of a data breach. A business interruption component, not in all cyber policies, but quite a number, and particularly for universities and schools, it would be for tuition and revenue loss. And finally, another first-party property coverage would be for actual damage, perhaps, to your network systems or hardware as a result of a data breach. So it really can provide coverage for a host of first and third-party losses. The key point here is that all these policies are not created equally, and as we're going to discuss, there's efforts afoot really by all of the underwriters in this space, including the Lloyd's market, to make changes. And so I really would recommend across all your lines of coverage, if there's one to be mindful of each year, you should always review and try to get enhancements, but your cyber policy is really one where there are changes, not going to be changes you request, but ones that will show up in your policy, and you need to be aware of those. And on the renewing front, and that is renewing your cyber policy, 2 or 3 key points here. As Janet was alluding to, you're in crisis mode after a data breach. You want to have not only your incident response plan planned out, it needs to have the component as well that you've got vendors as well as your legal counsel, and to have that approved by your cyber insurer. And your broker can assist with that at the time of renewal. Importantly, applications for your cyber policy renewal. We have seen this just building year after year. They're becoming much more rigorous and really are important. One thing we see right off the bat when a cyber claim comes out is the insurers looking at the application to see what statements were made about compliance with internal procedures, answers with regard to has the company on the application, put in place all updates for software. So there's a host of questions, as you know, that are asked at the time in the policy. And to the extent that there's an omission or a misstatement that would have some relationship to the data breach at issue, you can certainly count on the insurer to potentially raise an issue of rescinding the policy based on failure to either provide complete information or inaccurate information. And I always advise risk managers and legal departments to, have a couple folks, particularly someone in legal. If you're using outside coverage counsel, I would suggest that you do so. It's important just to make sure you're not overstating something that may come back to bite you later. And a lot of these applications will have yes, no options, and it really in many cases doesn't fit. And if it doesn't, then you just need to be able to note on the application that you're going to provide a narrative and not get boxed into yes, no. While it is, has been a hard market, particularly for D&O, we're starting to see it soften with premiums coming down a bit. But with cyber in particular, it's one that really does depend on the specific risk. And as I noted, there are efforts afoot to add sublimits for certain types of coverage we'll talk about, and also add some potential exclusions. And we'll talk about one in a minute related to hostile attacks and wars. We'll spend just a few minutes here very briefly talking about what we refer to here at McGuireWoods as the silent cyber coverages. And that's a little bit of a misnomer, but really just to have clients and universities be aware that there really are several other policies that can and do provide coverage for certain losses in addition to your cyber policy. A couple of those we've listed here, and again, both first-party and third-party coverages. The first party would be your property policy. Again, that may be for damage to network equipment, network systems, your crime policy. Usually the ransomware cover is in the cyber, but you'll see sometimes where there's some form of ransomware coverage in the crime policy. On the third-party liability side, you've got your CGL, your commercial general liability and excess umbrella policies, and then two executive risk type policies, directors and officers, and errors and omissions. And certainly the D&O cover may depend on whether or not companies are public or not, which will then really be a key factor in whether or not there may be coverage for something other than a securities claim. But clearly these are ones that do need to be reviewed and considered. If you do, again, you have a security suit arising out of a data breach, that would in fact and should be covered by your D&O policy. So as you go to work with your broker to notice under your cyber policy when you have a data breach, make sure that part and parcel with that you're looking at other coverages that may apply. Now, there have been just a couple quick developments on the cyber insurance front with case law. One going to CGL insurance, and I think the industry and even policyholders and brokers had been a bit pessimistic about whether or not you can get coverage under CGL policies. And the Target case last year is a prime example where you can. And in that case, there was a loss of use that constituted the physical damage under the policy as a result of the data breach. And there were significant costs for that loss of use that the court held would be covered under the CGL policy in the Target case. Under the CGL, similarly, there was advertising injury coverage that was triggered where a bad actor published stolen medical records on the internet. And probably the most noteworthy is the Merck case. That was under a property policy where the court held that Merck was entitled to $1.4 billion in property damage to system hardware following a malware attack. The insurers really had relied on a war exclusion, and essentially the court in a nutshell said that you really need hostilities in the sense of like actual hostilities, firearms, and that the war exclusion had never been applied in looking at case law and circumstances of a data breach, which is a great development for policyholders. There are, of course, cases that have gone the other way on the property damage side, and we've noted here the EMOI case. As a result of the Merck case, certainly insurers took great notice. We've got a sample here from the Lloyd's syndicate market, where they issued a bulletin last year requiring that all cyber policies that are issued through Lloyd's of London must have a broader form of war exclusion that would cover state-sponsored attacks, and essentially to undercut this ability based on the Merck holding to get cover even where there's not, actual hostilities. And importantly, we've noted here that's for all policies to be issued effective March 31 of this year. So really keep an eye out there as you're renewing your coverage. I'd spend just 1 minute on False Claims Act coverage. If you've got a hospital system as part of the university and you bill Medicare, or if you've accepted CARE Act funds or other funds as a result of COVID-19, there's the potential that you could have a whistleblower or potential DOJ investigation if there was allegedly false information submitted. Here we've just noted we cover under various policies, once again, that you would need to look at. Usually any cover for FCA claims would be in the D&O policy, but we do see it other places. The key issue really for FCA claims in the past has been whether or not payment for FCA claims or resolution that a university may pay, is that uninsurable, or is that a return of funds? Is it restitutionary? And there have been several courts that have said that's an issue of fact. And in fact, under the False Claim Act itself, it states that it is not for the purposes or is not considered restitution. And a lot of policyholders don't recognize that, and really sometimes, brokers will say that there's no cover for FCA settlements, and that's just not always the case. One other quick point here on this is specific to universities and to schools here. As you know, a lot of universities, most in fact, will carry what is referred to ELL coverage, and it's essentially I'd say a hybrid of D&O and E&O cover for claims, that would be a mixture of one or both of those. What we see happen here many times is that insurers, your CGL insurer and your ELL insurer, whether it's United Educators or one of the other specialty insurers who write the ELL coverage, it's kind of the pointing the fingers of each other to each other, and which is really going to step up and pay. And the point here is, universities shouldn't be penalized for buying additional adequate coverage and specific coverage in this ELL program. The point is you need to have a coordinated effort up front with your broker and your coverage counsel to make sure, depending on the facts of the claim, that one of the two really should be stepping up in a primary capacity. And then the other, again, it shouldn't be just one set of limits. If both provide coverage, then whichever one is not primary should then step in and provide excess coverage. And that's just, again, kind of a point to be aware of when the claim comes in. think I'm going to just let you have these notes here on commercial property policies and crime coverage. I'll say just very quickly in the 30 seconds here, this really goes to your renewal of the coverage. Be looking at stated values. They usually are not binding for purposes of how much you can recover for property damage or business interruption. They're really only supposed to be used for premium purposes. You need to make sure your policy states so. In any event, look at those, make sure that they're up to date, especially for any antiquities that the university may have, so there's no surprise if there's a claim. And we've noted that to itemize your specific pieces of property anyway, or to consider doing so. And those are kind of the key developments and thoughts on the insurance coverage front.
Thanks so much, Tony, and thanks, Janet, as well. As predicted, I'm impressed. We finished like on the minute. We will make sure to send these slides and a video recording around to those who attended and those who registered but were not able to attend. And I saw a few questions coming through, and we'll make sure to review those right after this and get you responses promptly. So thanks so much, everybody, especially to my co-presenters, and we'll see you next quarter. Bye-bye.